So you own a pretty catchy .com domain name to sell your goods and services, sort of like what Amazon.com does. So why should you still register a trademark? Well, imagine you own a piece of property, a car say, or a plot of land. What's to stop someone from coming over and saying that it's their land, not yours? Well, you have the deeds and proof of ownership to show that the land legally belongs to you in order to avoid this from happening. A trademark registration is very similar to this. It might sound simple, but you'd be surprised how often ownership disputes occur. New businesses and people choose the same word or word combinations already being used and trademarked by other brands. If you don't register yours, then down the line you may get third-party claims against your brand. These usually involve messy and costly legal proceedings to establish whose rights are earlier and stronger. This is where trademark registration comes in handy. It records when you stated your claim for that particular brand. In addition, the process of registering a trademark usually includes publication of your claim to the public for a period of time in which anybody can raise an opposition. Trademarks also help if there are disputes about who is entitled to social media handles, like getting a channel on YouTube or a Twitter handle. Even if you initially managed to convince YouTube to give you the channel name, if anybody else owns a trademark registration, you run the risk that they will approach YouTube and demand that your channel name be taken away and given to them. Anybody can. Whether a regular citizen, a legal professional, or a corporate entity, you can apply for a trademark. For U.S. trademarks, you do not need to be an attorney if you're an American citizen or the applicant is a corporation or organization domiciled in the U.S. But often you may want to use the services of an attorney to avoid some mistakes that could ultimately lead to not getting the trademark registered. And that's where the Trademarkers Network comes in. You see, there's only a limited amount of words and pronounceable sounds in the English language. So the catchier your brand is, the more likely it is that somebody's already filed for it or is granted a trademark before you. But for this person to retain the rights of a trademark registration, they also need to use it and declare such use to the trademark office. But a trademark is also granted in one or more specific classes. For example, retail clothing or software consulting. For each class, you need to describe the goods or services you will be using the trademark for, and importantly, provide proof that you are actually using the mark. So it's worthwhile to seek guidance for these critical steps to place your brand in the right class to suit your business needs. If during the publication of your trademark application, somebody feels that they should be entitled to the exclusive use of the mark instead, they can file what is called an opposition. The result is that the U.S. Patent and Trademark Office, or trademark office in the applicable country, then goes through the process of determining who has an earlier priority date and stronger rights, and then makes a decision whether to grant you the trademark or not. During these proceedings, both the applicant and holder may submit evidence as to who started using the trademark earlier and who is legally entitled to its ownership. Please feel free to watch more of our videos to get valuable insights about the mechanics of applying for trademark registrations, defending your marks, opposing other conflicting marks, dealing with office actions, and many other intellectual property issues. My name is Jonathan Morton, and I'm a licensed U.S. attorney and a member of the Trademarkers Network. Don't forget to subscribe.